And we are live. Welcome to the Rebel Esquire YouTube channel, LinkedIn, Facebook, all kinds of fun things. I am lucky enough today to not be talking to you most of the time here. I have Joshua Cohen, and Joshua Cohen is the student loan lawyer. He has been doing this for many, many years. In fact, one of the very first conferences I went to when I was a brand new baby bankruptcy attorney, I met him there. And I think it was one of his first conferences at that bankruptcy too. And it's funny how the world comes around 15, 20 years later sometimes. So thank you for being here, Joshua.
Oh, thank you for having me.
So we're talking about student loans. And the way this all came about was there was an article that came out of all these changes with student loans as of August 1st and everyone freaking out and attorneys not knowing what to do. So I was like, well, let's talk about it. So everything here is current status. Josh is the expert. He's going to talk us through a bunch of different things, but can you give us a outline a little bit of the types of student loans that are out there right now?
So, all right, when we talk about types of student loans and how I always start conversations with clients and other attorneys is, are we talking about private student loans or are we talking about federal student loans? That's our first question always. And it's important because sometimes the client will say, well, Sally Mae. That doesn't answer my question because Sally Mae does both.
Yes.
So,
Well, and I think people miss that too. Like that's the first analysis, right? Like you have to know what type you're dealing with before you can even start in with all of the different options. Because what's the key difference here between different student loans?
So, all right, when we talk about federal loans versus private, two key differences. One, available payment plans, and two, default remedies. What happens if I get in trouble? Very different on federal loans versus private loans. But again, the first one, the repayment options, how do I stop from getting in trouble? You got much more flexibility with federal loans. Private loans, I like to say, their choices are pay or don't pay. That's not much of a choice that you're making.
Really good choice. Yes.
Yeah.
Okay.
So,
And then talking about federal, so I think a lot of the confusion comes up is there are all these different programs, there's all these different things, and it's convoluted on purpose, I believe, in my opinion. It's purposely a mess. So what types of federal student loan programs are out there?
So what we start at is when we talk about federal loans, there's actually a difference within the federal loans as well that we have to start with. I mean, talk about convoluted. Oh my God. And this is something that I don't hold against clients if they don't know this, because why would they?
Right.
And this difference hasn't mattered until this past decade. When I was in school, it didn't matter. And that difference I'm talking about is something called direct loan versus FFEL, Federal Family Education Loan Program, FEL, whatever you want to call it. The key difference is who originated my loan.
Okay.
If you went to the Department of Education and borrowed directly from them, it is a direct loan, directly from Ed. If you borrowed from anybody else, it's an FFEL. I don't care who it was. It wasn't Ed, it's FFEL. Why does that matter to us now? Because not every program is available for FFEL. We know about income plans. We talk about income-driven repayment plans.
Mm-hmm.
FFEL is limited to one, only one. And the only one it can have is what we call income-based repayment, IBR. And the other key difference, we always talk about public service loan forgiveness, which is in the news right now.
Mm-hmm.
FFEL can't have it.
Really?
But I'm a teacher, but you can't have it. There's a way to fix that. So,
And a lot of this is just being informed and realizing that like your entire job is dealing with student loans because there is so much to know about dealing with it and trying to one off it or
yeah,
half-ass it. Yeah.
no, and the problem is I half blame servicers for screwing people. And I say half blame because they work off of a script. If you don't know what to ask them, they can't give you the proper response. And not many of those customer service reps have the forethought to skip around the script to find out what you're really asking for. You'll ask, are my loans eligible for PSLF? Well, they could be. What does that mean? Are they or aren't they? The real answer is no, you have FFEL. You need to do XYZ and then you can have it. It's not hard to say, but it's not in their script.
Right.
So,
And they probably don't want to give advice, but they're giving bad advice a lot of times. So I shouldn't even say
yeah,
that. Yeah.
they give outright wrong advice all the time. I mean, honestly, servicers are one of the best lead generators for my practice ever. They're guaranteed to say something that you need a second opinion on. I go, no, that's not right. I mean, one of my favorite ones, they used to tell people you don't make enough for an income-based repayment. No, that's the whole point. You don't earn enough and you get a $0 payment. Nobody is too poor for income-based repayment. That's ridiculous. But they would say it.
That's crazy. That is insane that's what they would say.
Yeah.
The whole point of it. Yeah. I think what's come up a lot lately, especially in the last month or so, is some of these limits, like the limits that are available for different types of loans. What's the status there? What's changed on federal loans?
All right. So this comes from the budget bill, which really did a doozy on things. The first thing to know is none of those limits go into effect until July 1st, 2026.
Okay.
It doesn't affect those of us that have loans. It only affects those who are getting new loans after July 1st, 2026. So if you're graduating in 26, great, not going to affect you. If you're still in school, it could affect you. If you're starting school in 26, fall of 2026, you have these new limits. Now, so let's talk about it. For undergrads, everyone gets Stafford loans.
Right.
But Stafford loans right now, they come in variations. There's subsidized and there's unsubsidized. That's gone starting in July 2026. There's only unsubsidized. What does that mean in English?
Okay.
A subsidized loan means the government will cover your interest while you're in deferment, while you're in school. Okay. Unsubsidized means too bad. So sad. You owe it all. Well, as of July 2026, all loans are unsubsidized, no government subsidy on it.
And that means they accrue interest from the day you obtain them.
From the day it disperses, boom, you're hit with interest. By the way, interest in all of this is kind of a red herring because of other plans. We're going to talk about payment plans. But that's the first one, is they got rid of it. They also are getting rid of Grad Plus loans. Okay.
That's scary. A lot of us went to school on Grad Plus loans.
It is, but here's the thing. Did you know that Grad Plus loans didn't exist until 2007? There were no Grad Plus loans for 2006.
Okay.
They came into being while I was in law school, not because of me, I'm not taking credit. But like my 1L year, I didn't have a Grad Plus. They weren't there. My 2L year, I got one. It just means I didn't need a private loan. However, they kind of offset it by new Stafford limits. So right now, graduate Stafford is capped at $20,500. Okay, per year. Starting July 2026, they differentiate what the graduate loan is for. If it's a graduate loan for a non-professional degree, just a master's or a PhD, then you're still capped at $20,500 up to $100,000 total. So 4 years of a graduate degree. If, however, it's for graduate, a professional degree, like a JD or an MD, you're allowed to have $50,000 a year in Stafford. So you don't need the grad, hypothetically. And you are capped at $200,000, which is 4 years. And we should get through law school in 3, medical school,
I was going to say, that may be a problem for med school.
Yeah, well, hopefully you do it in 4 years. Um, so that's the new cap. They got rid of the grad plus,
Okay.
and you're capped with just this new Stafford cap program. The
Okay.
biggest cap, however, and I'm not going to opine if I'm for it or against it, I'm sort of on the fence, are parent plus loans.
I was going to say, what's the change there?
So parent plus loans right now are not capped. They are meant to be a filler between what the student receives in all aid, both federal loans and grants and scholar and work study, and to fill in the gap between that and whatever the total budget is, not just tuition, the full budget. And remember, budget is tuition, books and fees,
Housing.
room and board, transportation to and from, all of this stuff. It's not uncommon to see an ungodly amount for the budget. So, which is why we saw Parent Plus loans for $20,000 to $40,000 a year.
Crazy. Yeah.
Crazy. After July 1st, 2026, they are capped at, where's my cheat sheet? $20,000 per dependent per year.
Okay. And
So
limit, right? Beyond that.
that's
Total
the
limit.
limit for, yes. And then they also limit it per dependent, regardless of how many people are borrowing. So, for instance, we have two kids,
Mm-hmm.
both in college. Mom can take 20,000 for kid one and 20,000 for kid two. Dad can take 20,000 for kid one and 20,000 for kid two. The most that is allowed to be borrowed for kid one total is 65,000 a year, which I'm not sure how you hit that unless there's maybe a step parent that also takes a parent plus loan. I don't know.
Yeah.
So, but so it definitely limits. We're not going to see runaway parent plus loans the way I've seen them of
Right.
150,000 or more.
Mm-hmm.
But it begs the other question, where's the money coming from then? Yes, this is an inroad for private lenders. No way about it.
Yes. Without any kind of reform as far as cost of
Well,
education
that
goes.
actually, there is the question.
Yeah.
If the middle class suddenly can't afford college, will college start reeling in their cost? Now, there
Yep.
is another, I don't really talk about this much because I'm still learning it. They are redoing how they figure the cost of attendance,
Okay.
and they're actually collecting data from schools so that they can aggregate and figure out cost of attendance based on major.
Interesting.
So that, and they're sort of leaning towards crafting limits based on the major you declare, which means we're all going to declare I'm pre-med. Um, because philosophy majors, you're not going to get anything. They're aggregating that with also data afterwards on what income is.
Yeah.
It's really weird. Welcome to, I don't know how this is going to work. I just don't.
We probably go off on a whole tangent of only economic benefit being the outcome to
Yeah.
society. Yeah.
So it
Whole
could
tangent.
be worse. It could be AI determined, like they're doing with not even getting there. Sorry. Um,
Okay. So what I get a lot of questions for, and as bankruptcy attorneys, I work with a lot of bankruptcy attorneys and a lot of consumer type debt attorneys these days. Repayment plans. Are there, what kinds of changes are coming to these repayment plans then?
so again, I'm not going to opine on whether I think it's good or bad because there's both. The problem with our current system, there are 9
Yeah.
different payment plans.
Yeah.
9. It's analysis paralysis. I love that one. And it is. And look, there's a reason why I have so many attorneys as clients. Okay.
Right.
Because if an attorney can't get through something, that means something's wrong. It's too convoluted.
Right. Yeah.
So right now we have 4 different plans based on paying off the loan. And then 5, well, this is changing, 5 income plans. So
Mm-hmm.
right now, if you want to pay off the loan, you can do the regular 10-year term, or you can consolidate and get up to 30 years.
Okay.
You can do an extended 25-year term if you owe more than 30,000. You can do a graduated plan, which is still 10 years, but steps up. That's okay, because you make
Yeah.
more money as you work.
Yeah.
Or the best one, a 25-year extended. You get 25 years to pay it. It steps up every 2 years. People get a raise every 2 years, right?
In
So
theory.
it sounds affordable.
Yeah.
Starting for loans that are originated after July 1st, 2026, what
Which is
I'm
an
calling,
important point here. I'm going to point that out there, that's a very important point because everyone's freaking out about their.
right. The changes are based on the loan origination, not on the year you sign up for anything.
Right.
Okay. And actually, this is important. One of the terms that has been developed and it's not necessarily adopted by ed, but it's being adopted by student loan professionals is
Mhm.
legacy loans versus
Okay.
what I'm calling BBB loans, better budget bill bullshit, whatever you want to call it.
Whatever. Bunch of bees. Yeah.
So
Okay.
if your loan is originated before this cutoff, July 1st, 2026, it's a legacy loan. It
Okay.
can have any of the 9 plans I spoke of for now. But if you have a loan originated after July 1st, 2026, it has different plans and only has 2.
Okay.
Simplicity is good. You have 2 plans. One is pay it off, and that's easy. It's the term is based on how much you owe for your full ball of wax,
Oh,
not
interesting.
per loan. It's just full ball of wax. So, and they've got 4 tiers, up to 25,000, 25 to 50, 50 to 100, and anything over 100. And
Okay.
it's 10, 15, 20, or 25 years. That's it. That's simple brackets. Very simple to understand. Kudos for that. Great. We
Right.
can understand. And that is a pay it off plan. There's no graduated plans. There's no extended plans. It's here's your term, pay it. Fine.
Okay.
The other plan, which I'll go into in a minute, is an income plan. That's RAP, Repayment Assistance Program.
All these acronyms we have to try to remember with
Yes.
IBRs, ICRs, and IDRs and crazy stuff.
Yes.
Yeah.
I love acronyms. Yay.
Yeah.
So
Okay.
so RAP is what's out there. So
Okay.
if we so that's it for standard pay it off plans. If we talk about legacy income plans,
Mhm.
okay, that's where you have alphabet soup.
Yeah.
All right. I'm going to try to make this as simple as possible. IDR, income driven repayment, is a hub term. It
Okay.
means any plan based on income.
Okay.
Technically, RAP is an IDR. Okay. Now, when I say IDR, I'm referring to income contingent, ICR, income based, IBR, pay as you earn, pay, new IBR, which is like new Coke, it's a little sweeter. And the now defunct repay and save. Save is dead. It's not coming back, and neither is repay.
Okay.
Okay. So we're down to just 4: ICR, IBR, pay, or new IBR.
Okay.
Okay. And everything they were, they still are. This is where I can tangentially go into the save litigation updates.
Yeah.
Just,
Yeah.
just for clarification.
Yeah. Go
Okay.
ahead.
And we are in an injunction right now. And that injunction says you can't have save. So anybody who is in save as of July 2024, you are in an administrative forbearance.
Okay.
And as of August 1st, 2025, interest started accruing because the Department of Ed made up, oh, well, it's in the injunction. No, it's not. It is not. But who are we to say?
But we just make up things now. That's how it works.
Yes. Well, you have a wrestler in charge who wrestled that out of the decision,
Yeah.
I guess. Anyway, so interest is accruing now.
Okay.
That save administrative forbearance doesn't count for anything. It's not getting you credit towards forgiveness or public service loan or anything. You are treading water, watching the Titanic sink. That's what you're doing.
Okay. That's good to know. So people need to do something if they were on
Do
save.
something. Now,
Do
there
something.
are some people where it makes sense to wait.
Yeah.
Maybe their income is about to change in a few months and they want to wait. Okay, fine.
Yeah.
But don't wait long term. On that note, many people have received your forbearance for the save plan is ending soon.
Mm-hmm.
No, it's not. The save administrative forbearance lasts until a decision comes down, until that case is resolved. Now, they just requested a 90-day continuance. When both sides agree, why? Two reasons. One, who's officially going to kill save? Ed or the court? That's number one, but that's minor. The real issue is once it officially dies, there's going to be a mass migration out of save. The Department of Ed will be forced to move people out.
Okay.
And the problem is, never mind servicers not knowing what they're doing,
And giving wrong information.
where are they migrating them to? The Department of Ed doesn't have RAP released yet. And I haven't explained the program, I'll get there. But RAP
Yeah.
isn't available yet. So it is my theory, and many experts agree with me, that they are going to roll out RAP as soon as they can. And once it's rolled out, then they can get rid of SAVE and migrate people over to either
Okay.
RAP or one of the IDRs that's still available. So that's the only reason this lawsuit is still alive. And while it's alive, you can still have forbearance.
Okay.
But don't
Interesting.
sit there unless your income is going to change, and that's what you're waiting for. So here's the other details you need to know.
Okay.
Right now, under the injunction, you cannot get forgiveness for ICR, and you cannot get forgiveness under pay.
Okay.
You can still sort of get forgiveness credit, but you can't get awarded the actual forgiveness. The only program that awards actual forgiveness is IBR. By the way, when I say IBR, I also mean new IBR. They're the same.
The same rules apply. Yeah.
So if you're in IBR and you hit the mark 25 years, you can have forgiveness right now. Small exception, Ed has put a pause on awarding IBR right now, forgiveness, but it will start. I believe it'll start soon.
Okay.
And by soon, I mean in 3 months. And you can have it. So what I'm telling people is switch into IBR, start getting your credit.
Yeah.
Can you switch into ICR or pay? Yes, but those programs are sunsetting July of 2028.
Okay.
If you're in those programs, you will automatically be sorted or funneled, I should say, into IBR or new IBR if you're eligible for it. Okay, so that's going to be automatic. But if you want those plans, you should be in them soon.
Sooner rather than later.
Just do it. But you have until July 1st, 2028 to do whatever. Okay.
And for the lawyers watching this right now, this is exactly why you should at least know the basics of this to talk to your clients and refer them to someone, because I'm not memorizing all this stuff. Sorry, I'm not in my head.
You know, the
Yes.
thing I love about bankruptcy attorneys, they understand math and they understand a lot of things. And hopefully they see a tangential and go, you know what? I don't do this, but here's a guy that does.
Yeah.
I
Yeah.
think bankruptcy are great places to find the value add by
Mm-hmm.
networking with other folks.
Yeah.
That said, there's more.
Let's talk about RAP then. I think that's next on my list here. What does this new repayment assistance plan mean?
Okay, so for RAP, it is a very simple formula.
Okay.
Okay. Sorry, with RAP, it is based on adjusted gross income. Well, what if I file jointly with my spouse? Then it's based on both of yours combined adjusted gross income. That's the same thing as IBR. There are ways to get around it. We don't know how with RAP yet because it's not released. If you file your taxes separately, then they will only look at your AGI. Okay.
Okay.
I don't talk about tax consequences, not my lane.
Right.
So with RAP, they look at your AGI and they tier it. Every $10,000 of AGI, it's a very simple formula. They look at your AGI, they take a percentage of it, and that is your annual payment divided by 12 for your regular payment.
Okay.
If you make under $10,000 a year, your payment is $10 a month. That's the floor. With the other IDRs, the floor is 0. With WRAP, the floor is 10. You have to make a payment of at least $10 a month. Okay,
Okay.
fine. I don't know what that's for, but whatever. So if you make between 10 and 20, they want 1% of your AGI. So at 20,000, they take $2,000 divided by 12. That's your payment.
Okay.
Every 10,000, it steps up by 1%. So that eventually, if you make over 100,000, you're paying 10% of your AGI.
So that comes out to like $833 per month if you don't have any
Right.
dependent, basically.
Right.
Okay.
That's it. It's very different than the IDRs, which look at poverty index and family
Right.
size.
Right.
Here, the family size only matters this way. You get a $50 a month reduction for each dependent you claim. So if you claim one person, you can reduce it by $50 a month.
Okay.
Two, it's $100 a month. That's it. Okay. If you don't claim them as a dependent, you don't get the deduction. So very different than IDR.
Is there negative amortizations or is there an interest waiver on NRAP?
What a great question. Yes, that is one of the advantages of WRAP. Okay.
Okay.
The biggest advantage of WRAP is it has an interest waiver, meaning if your payment doesn't cover all of the monthly accrued interest, the government will waive any accrued interest that isn't paid with your payment.
Well,
Now,
that's
what's
good.
funny,
At least that part of it.
and what's funny is this is one of the provisions that caused the SAVE litigation. SAVE has this interest waiver. Conservatives said that's too generous, and yet they put it in their program. Why?
Yeah.
Well, actually, it's a good thing. How progressive of them. Ooh. But wait, it gets better. This is like a Ginsu commercial, isn't it? Okay. The other advantage is on the WRAP program, there is a $50 principal reduction.
Oh,
Meaning, if
okay.
your payment doesn't reduce the principal by at least $50 a month, the government will reduce your principal by no more than $50. So if your payment reduces the principal by $10, the government kicks in the other $40 so that your
Okay.
loan will reduce by $50 a month. So you get the interest waiver and a principal reduction, and it has nothing to do with how much money you make. It has everything to do with how much your payment applies to the loan. That means the lawyers that owe 150,000 that are making 100,000, your payment may not be covering all of the interest and reducing principal. You still get the benefit. That is the biggest advantage of WRAP.
That is a great thing because looking at my student loans and what I ended up paying off was like 3 times what I borrowed by the end of it
Yeah,
because of all the
yeah.
interest that was accumulating during various times. So
So
that's good news.
the key difference, IDR has negative amortization. Your interest is going to roll up. Doesn't capitalize, but it rolls up. WRAP won't have that. The disadvantage, IBR is a 25-year forgiveness. New IBR is a 20-year forgiveness. WRAP is a 30-year forgiveness. So
That sucks. But on the other hand, I think more people will be able to pay them off with interest not being. So I think one of the reasons forgiveness is needed right now at 20, 25, and 30 years is because
yes,
balances have ballooned so much. So
right. And so at the end of the day, this all comes down to knowing how to use a calculator and running the numbers. And if you don't, there are people that can do it, that have software that's doing this. Happy to talk, because the other problem is tax bomb.
Yeah.
Right now, all of these plans could be taxable. Let's put the lingo correct. You're going to get a 1099-C, cancellation of debt. Is that taxable? I don't know. Ask your accountant. Ask your tax attorney. They have magic too. But we don't know if Congress is going to wake up and make this non-taxable. I think they will. I really do. Not this one. But there's been lobbying from both sides of the aisle to make it non-taxable. I think given time, it will be.
Okay.
We'll see.
Okay, let's dig into a few more things before we have to wrap up because there's a lot. You have so much information in your head, and there's so many things we could talk about for hours and hours.
Yes.
Um, One of the hot topics these days is public service loan forgiveness. Where we is that does that still exist?
Okay. Let's refresh about public service loan forgiveness and how it works, because there are people that miss details. There are three requirements here. Number one, the one you can't miss, only direct loans qualify. If
Okay,
you still
very
have an
important.
FFEL from back in the day, you're not getting any time. And worse, you missed an opportunity. Under the Biden administration, you could have consolidated before June of 2024, and they
Mhm.
would give you retroactive credit. So even though your FFEL didn't get credit, if you had done the consolidation on time, the Biden administration said, we know what you tried to do. We're giving you the credit. If you still have an FFEL, ouch. Okay, so FFEL, yes, no, doesn't get PSLF. Number
Okay.
two, you have to be working for a qualified employer, which right now is a government, federal, state, county, municipal, Native American also
Okay.
counts, um, or a 501c3 and certain not for profits. I'm going to come back to this tab in a minute.
Okay.
And you just have to be doing 30 hours a week or more. Doesn't matter if you're full time, part time. Are you doing 30 hours a week or more on
Okay.
average?
Okay.
Fine. And the third point, qualifying payments, which is going to be IDR or RAP or 10-year standard payments. If you have a 15, 20, 25-year payment, that doesn't count. Only 10-year does. But any IDR and RAP counts. But I'm in forbearance and you're not getting credit. But I'm making voluntary payments. You're not enrolled. But I'm on the save administrative forbearance.
Doesn't
No,
exist.
doesn't exist. Now, there is a nice program out there which is working. It's backed up called buyback. If the months that you're missing for a forbearance would be enough to put you at the 120 months that you need, you can petition to buy back those forbearance months, meaning you would pay them lump sum what you would have paid, and boom, you're at forbearance. And here's the kicker, they're actually right now allowing people to do it at the save rate.
Hmm.
I don't know when that's going to end. Don't quote me. It could
That
end
done.
tomorrow. They could
Right.
see this video and go, whoops,
Right.
what? Yeah, anyway, um, so that's if you have the money, boom, and now you qualify for it right now. Otherwise, get into IBR, start getting the months that you need. So you need all three of these simultaneously for 120 months, no earlier than October 2007. But I was a teacher in 05. That's great, but it doesn't do anything.
Right.
Now, let's go back to the qualifying employer because this is in front of, well, not
Yeah.
in front of Congress right now. There's negotiated rulemaking on this.
Yes.
President Trump signed an executive order a long time ago that would limit PSLF, or I should say, exclude currently qualifying employers if they are doing things that this administration deems illegal, such as a nonprofit that supports trans counseling or supports immigration reform
Sounds like
or yeah. So right now there's negotiating rulemaking to codify that and to say, okay, if you're doing XYZ, even though you're a government or a 501c3 agency, you don't qualify for PSLF because you're doing these things that the administration doesn't want you to do.
hmm.
I already know there's going to be lawsuits on that
Of
because
course.
this is the exact same overreach that the SAVE lawsuit is based on.
Hmm.
Congress legislated government 501c3. Ed wants to further qualify it. Congress created IBR. Ed wanted to further clarify it and created SAVE. So to me, the lawsuit's there. We'll see where it goes. But this is, what's the word? Horrifying.
I,
It's
I just like go back to like free speech. There's all kinds of problems with this.
There's all kinds of problems. This is politicizing PSLF.
Yeah. Yeah.
That's what. So
Okay.
abortion clinics are going to have a problem now. Planned Parenthood, because a piece of what they do is considered illegal under this administration, they may not qualify for PSLF. So that's a huge deal.
Okay.
Um,
So keeping up on that is like a full-time job. That's what you do all day, huh?
Yeah, and there are plenty of other sources. I love Adam Minsky. He's a writer for Forbes,
Yep.
but he's a student loan lawyer, and yep. I love reading his articles. Like, oh, I forgot about that. Let's go look. So yeah, great resource.
Yeah, there's some good resources. There's some great student loan lawyers out there. And that actually brings us to like my next section here is like default. And what do we do with some of these that are in default? Because as bankruptcy lawyers, we get people in default all the time. And bankruptcy, you may not help, but what's default mean?
Okay, default means you stop paying your loan long enough that it has come off the books and it is deemed uncollectible in the sense that they're not expecting you to pay it. It's still collectible. They're going to come after you, but they've moved it. They've accelerated it. You owe the full amount right now. Okay. It's similar to charge off for credit cards, but federal loans don't charge off in the same way.
Right.
And default for federal loans takes 9 months. You've got to miss 9 payments before you default. Okay. You have time to fix that. If you missed a few payments, get on an IDR payment. Okay. Because they'll also give you a hidden forbearance that brings you back up to 0.
I was going to say it brings you current then.
Yeah. They don't start you an RBR saying, oh, you still owe us those back months. No, they'll start you fresh. So sign up for IBR. But if you're not paying attention, it happens. It's called life. You default, you're in trouble because collections has started up again.
I was going to say, what are our consequences once default has happened?
Okay. So number one, there's collection conduct.
This is federal. Yeah.
There's collection conduct, debt collectors. And it looks like the Department of Ed isn't going to outside collectors. They're using Default Resolution Group, which is not an in-house, but sort of an umbrella in-house. It's still a third party, but they call from the Department of Ed and they want you to start paying again. Now, their job is to offer you a way to get out of default. 2 ways to do that. Consolidation, rehab, I'll come back to that. So we have collection conduct. If you don't respond, well, they're going to start garnishing your wages. If you're a W-2 employee, they can garnish 15% of your wages, and that takes priority over judicial garnishment. So let's say Cap 1 sued you and they're garnishing, Department of Ed takes priority. Okay. That's a problem. And they don't have to sue you. This is called administrative wage garnishment. They send you a 30-day warning letter. I didn't get it. Too bad. They will garnish, and they just go to your HR department and they start garnishing. No lawsuit. That's a problem.
And Social Security. I get this question all the time.
This one annoys me the most. You're taking money from people that don't have it in the first place.
Right.
Okay. They can garnish up to 15% of Social Security. They do need to leave the debtor with at least $750 a month, which I don't know what that gets you. But anything over $750, they can take. Now, that's very easy to fix. Again, we can get you out of default. So Social Security offset. And by the way, Social Security offset is really a subset of any federal benefits can be garnished. So if, let's say, you get paid by the government as a vendor, they can take 15% of that vendor payment. Wow. Okay. That's a problem. Federal tax refund intercept. We'll start seeing this when refunds start coming out next April, when people start filing. Okay. You don't get that back unless you are an exceptional need. You're going to lose the federal tax. How do you stop that? 1, get out of default. If you need to buy time, don't file your taxes. Wait until you're out of default and then file your taxes. Jen, question for you. Do you know how long you can go and still file your taxes and get a refund. Do you know how long that window is? It's pretty
I think
big.
it's 3 years, isn't it?
It's 3 years. If you can't get out of default in 3 years, something's wrong.
Right.
Call me. Okay.
Call
We
Josh
can do
immediately.
that.
Yeah.
Yes. And the last one, I know we love talking about this, lawsuits.
Lawsuits. Yeah.
You can be sued for your federal loans. Now, if they can garnish your wages or Social Security, they're not going to sue you. There's no reason to. They can get at you anyway. The people
Right.
that get sued by lawsuits are what we call consultants or self-employed, because that's the only way to get it. And they will win the lawsuit. Okay. But you
And
can
then it's
always,
all the typical collections that they can go through
yeah.
to
So
bank accounts,
this
property.
is, yeah. Now I can tell you, no one that I know of has ever lost a house because of federal student loans. They don't want your house. They want money.
Right.
But they will put a lien on the house to secure an interest.
Yep.
Okay. But you can deal with
Eat
it.
up all your equity. Yep.
Yeah. So how do we deal with it? Okay. The permanent fix. Even bankruptcy is temporary here. Okay. If you file bankruptcy, it stops your garnishment until you come out of bankruptcy. Then why?
Yep.
Because
You do
bankruptcy
something
has
with it. Yeah.
discharged your loan. Yeah.
Yeah.
So how do we permanently fix this? One, consolidation, which is a federal program. You pay off your old loans, you get a new loan. Credit is irrelevant for a federal consolidation. You're allowed to have it.
Okay.
Or you do something called rehabilitation. Now, the only time you can't consolidate, there are two times. One, if there is a judgment, you can't consolidate. Or
Okay.
two, if there's an active wage garnishment. So for those people, we have to rehabilitate. Rehabilitation is kind of like a modification. It's a temporary modification. It is a payment based on a financial analysis. You have to make 9 payments. After you make the 9th payment, you're out of default and you sign up for IDR and you carry on.
Okay.
If you have a wage garnishment, they'll stop it after your 5th rehab payment.
Okay.
You still need to pay your 6, 7, 8, 9, but the garnishment will stop. This works.
Hopefully you can afford it then.
And it
Okay.
should be affordable because, again, it's based on a financial review. You can
Yeah.
have a rehab payment as low as $5 a month. So
Mhm.
you should be able to do this.
Yeah.
Again, I'm happy to help.
Yeah.
Now, what's also good to know, and for you bankruptcy attorneys, please pay attention. You can rehabilitate during a Chapter 13. There is language out there that will allow you to do your 13 plan, make your 9 payments under rehabilitation, and then roll them into an IDR during the 13, which means they're going to get IDR forgiveness credit during
That's it.
bankruptcy,
Yeah.
which could even translate to 4 or 5 years of PSLF. That's half of what they need for forgiveness.
Yep.
Most courts allow this.
And that's a special plan provision. That's just put it
Yes.
in the 13 plan. Yeah. Yeah.
So they could walk into the 13 to save their house, walk out, their loan's in good standing. They've gotten forgiveness credit. It's a payment that's affordable. It's a great way to sell 13s. There's
Yes.
no downside from the federal loan.
Yep. Okay.
So, I love it.
There's all kinds of fun things. I love 13 for a lot of reasons, but that's a good
Yes.
one. So we got rehabbing. How about deferments and forbearance? Do those still exist?
So they still exist. The important thing to know, legacy borrowers have a variety of reasons for deferments. If you're in school, that's automatic for any loan. Okay.
Okay.
Also, active military duty, that will be for any loan. But legacy borrowers will continue to have what's called economic hardship deferment or unemployment deferment.
Okay.
New borrowers after 26 won't have that. But the truth is, you don't need it because your IDR under RAP is only $10. And
Right.
under IBR, it's $0. If you're
Right.
unemployed, your IBR is $0. Don't tell me you can't afford that. You don't need a forbearance, okay? So economic hardship and unemployment deferments go away for new borrowers after 2026.
Okay.
But the biggest difference is going to be forbearance limits.
Okay.
Legacy borrowers get 3 individual 1-year forbearances for the life of each loan. So each loan can have up to 3 years of forbearance for whatever reason.
Okay.
New loans after 2027, not 26, 27, they get only 9 months of forbearance every 2 years.
Okay. So there's not
So while
cap.
you're not limited to the 3 years for life, you can only have 9 months every 2
Yeah.
years. I
Every
guess
two
they
years.
think it's because pregnant ladies need it. That's it. What? I have no idea what they were thinking here.
Sometimes you look at like the terms, the length of things. You're like, where did they come up with these random
I
dates?
really think that's what it is. You know what?
Yeah.
You're having a new family. You need 9 months off while you're pregnant. You have a kid every 2 years. I'm sorry. There's a model you can see here, right?
Yes.
That's the only thing I can think of. I don't know where it came from. Okay.
Okay.
Um, and
Let's
remember,
because this is my okay. Go ahead. Sorry.
well, I was just gonna say, forbearance is only for temporary issues. It's not a long-term solution. The long
Right.
term is the IDR and RAP plans.
Right. Because you're not going to get credit for anything if you're in forbearance. You might as well get
Exactly.
credit for what you're doing.
Okay, good
So
stuff.
my
You want
favorite
to talk about
topic is DOJ guidance for bankruptcy discharge. Bankruptcy attorneys, stop telling your clients that you can't get rid of student loans and you can't deal with them in bankruptcy. What's the deal with the DOJ guidance?
All right. Understand the case law has not changed. We're still under Bruner in the majority of courts, or the totality of circumstances in the eighth, or whatever the first wants to use. The law hasn't changed. What changed is the Department of Ed, Department of Justice got together and said, let's make a checklist for efficiency. And if people meet this checklist, we'll stipulate to a discharge, or in more cases, a partial discharge. Okay. Now, even in circuits where you're saying, oh, they're not allowed to have a partial discharge here. Understand, even in those circuits, they can discharge loan by loan. So maybe 2 loans are discharged and
Mm.
1 loan isn't. That's still a partial, but it's not a partial under the law. Okay, understand that? So what they've done to make it very simple is they're looking at the I&J schedules. If
Okay.
those I&J are 18 months or younger, they'll use that to figure out the first prong. And the first prong is so easy. Can your debtor afford a standard payment, not IDR, standard payment,
Standard.
yes or no, based on I&J?
Okay.
That is an objective question, not subjective. Can you use a freaking calculator? If yes, you know the answer. Fine.
Oh, you're
I'll
asking a
skip to
lot.
the third. I'll skip to the third one because this is easy too.
Yeah.
Their prior efforts to repay, have they ever consolidated? Have they ever applied for an IDR? They didn't have to accept it, but did they apply? Have they ever had forbearances, deferments? Have they ever spoken to a servicer or a collector or Department of Ed? And my favorite one, have they spoken to an expert that can help them? That's you, dummy. So yes, they make the third one. Where these cases pass or fail is the second. And the second boxes are fun. Is fun the right word? I don't know. So one of them is the debtor 65 or older? If they are, you're probably going to win.
Okay.
And here's a threshold requirement. The loans have to have been in repayment status for a decade, for 10 years or more.
Okay.
Now, what does repayment status really mean? It means they've been out of school. It doesn't matter if they've been paying them, if they're in forbearance, if they're in default.
Just have been due.
Have they been out of school for a decade? So the people that came to me and they graduated during COVID, you're not the case I want.
Right.
You've only been out for a few years. Sorry, no. What if they have some loans where they have been a decade and some aren't? Well, chances are the ones over a decade get discharged. The ones that aren't don't. That may not be a bad thing for your debtor.
Right.
Other things they're looking for. Has the debtor been unemployed for 5 or more years? And if so, why?
Mm-hmm.
Okay. Do they have a disability or a chronic injury that gets in the way of them, of their earning potential? It's not that they can't work. That's a
Right.
different discharge.
It's
It's
the
that
earning
they're
potential.
limited. They can
Yeah.
only do, 20 hours a week, or they can only do certain jobs, remotely because they can't stand for more than an hour at a time or something. It limits their ability to earn. Yeah, they can earn 60,000 a year when they should be able to earn 120. That can get you a discharge. And then there's the standard, they'll never be able to afford a significant payment, or they won't be able to pay for a significant time. Those are people that are either capped out in their profession and or
Okay.
have aged out. They're not retired yet, but they've been doing it for so long that, they're going to retire in a decade or sooner, and
Right.
or they're never going to get a raise.
Right. Right.
And now, here's my favorite example. Many
Okay.
bankruptcy attorneys say if they're Chapter 7, great. If they're Chapter 13, it won't work. My grandmother would say malarkey.
Larky, I agree.
That's malarkey. And then they'll say, well, it depends if they have, discretionary funds or not. They're above the median. No, stop. I recently received. Well, let me ask you this, Jen. I'm gonna ask you. I had a debtor who was 64 years old. She is an HR professional. In fact, she is the HR director,
Okay.
earning $180,000 a year.
Okay.
She owes 360, so
Mm-hmm.
twice what she earned. What would you do with that? Do you think that would be worth an adversary and at least see what you could do
Yes.
with it?
She's 64 years old. There's no way she's going to pay back 360,000. And
Yes.
yeah, yes.
So I took that case. She turned 65 during the process. Great.
Mm-hmm.
The end result, which we just got the judge to sign off of the 360, the Department of Ed discharged 297.
That's fantastic.
So she owes $60,000. She's still earning 180. Her
Right.
payment, her regular payment is $400 a month.
Okay.
When she retires, I'm going to roll her into an IDR. It'll be even cheaper. Will she pay it off? Who cares?
Okay. Yeah.
I sliced off 297, and because it was during bankruptcy, is there a tax consequence?
Nope.
No. Haha. So
Great reason to do this
look,
during bankruptcy.
you've got to look at these people. On the other side, I do these for people in their 30s
Mm-hmm.
because maybe they do have something. Maybe they do have a chronic injury,
Yep. Yep.
or they are limited in what they do. I also just got 50,000 discharged for a bartender. Her income's capped out at 35,000 a year. She's
Yeah.
never going to earn much. She
Yeah.
got 51,000 that's her entire loan balance.
Mm-hmm.
Discharge done.
Yeah.
So you really have
Perfect.
to look at these. I am happy to be a second set of eyes for anybody that wants it. I'm not looking to steal your case. I'll tell you what I think of the odds.
Yeah. So Josh, we have to wrap up because we've
Yes.
probably been going on and like I could listen to it all day. But don't you have a workshop next week where you're
As a
teaching
matter of
this?
I do. I run a 2-day workshop for attorneys and paralegals. Paralegals are welcome. And we do everything I would just talked about in depth for 2 days. The first day is all federal loans. The second day I talk about private loans as well. I spend half a day talking about adversaries on federal and private. And then we also talk about marketing, because wouldn't it be nice to have clients that pay you for this? And we talk about tools
Yes.
that are out there and things you can do. So two
Fantastic.
days.
And
Um,
what days are those next week?
it is Thursday and Friday, and it starts at 11 Eastern so that the
Okay.
Western don't have to get up early. Um,
Thank
and
you.
you still have time to sign up. You can get information at studentloantoolbox.com. Or if you come to my website, studentloanlawyer.com, you'll find it there. But go to studentloantoolbox.com. Happy to help you. I also, if you can't make this one, I've got another one coming in November as well. It's
Okay. Good
got
to know.
all of the new updates in it. So get on
Fantastic.
board.
And I will put both websites into the show notes and the description, and I'll put it on LinkedIn. So if you want to learn student loans, if you've gone through my bankruptcy workshop and you want to learn student loans next, or if you just want to do student loans, because there is so much work out there that you could just do student loans. Call Josh. Fantastic. I have actually taken his workshop about 10 years ago or so. That's where I learned a lot of what I know. And so it's a fantastic workshop. So thank you, Josh, for your time today. Really appreciate the race that we just did through like 40 years of student loan history. Um, and I look forward to probably talking to you some more. And good luck in next week's workshop. I think that'll be fun.
Thank you very much and happy to be here. Thank you again.
Thanks. Have a great weekend, everyone.